Hello, everyone. Thank you for tuning in today. Welcome to This Time for More Injury Funding, the podcast for all who want to learn about legal funding and its significance in the personal injury, right share, defective products, medical malpractice, tracking law, workers' compensation, and many other types of law practice domains. I'm your host, Laura, founder and CEO of More Injury Funding, the legal funding counselors with passion for law, medicine, legal funding, and heart for all suffering individuals. In today's episode, I have an honor to be talking to trial lawyer Jon Hawk with Hawk Law Firm based in Macon, Georgia. Jon, a 1997 graduate of the University of Georgia School of Law, go Dogs, gained valuable litigation insights in his early career with insurance companies. As a trial lawyer's college alumni, he develops effective strategies for clients and speaks at several legal seminars. Jon is involved in various legal associations and actively participates in his community and First Presbyterian Church in Macon. Today, we'll be discussing risk and reward, how to navigate trials when stakes are high. At the end of our episode, I prepared a fun pop question for our guests, so stay tuned. Welcome to my show, Jon.
Thank you so much. I'm really enjoying being here today. Thank you.
It's so good to have you on this Friday, beautiful day in Georgia. It's going towards the second part of May, so super exciting time for everybody. Jon, can you explain what a deposition is and its role in the legal process?
Sure. And, when we talk about risk at trial, which is kind of the second part of our section, the depositions are so important because that's when you decide for yourself what does my case look like? What are our strategies, themes, and how do we move forward with the case? And do we need to take risk that we need to be thinking about? But I've through a lot of trial and error over the years, and for a lot of input from other lawyers, I've come up with what I would call the 5 sections of every deposition. And it's when you have 5 sections, it makes it easier for clients to prepare. Section 1 through 4 are sections that probably all of us have been through, and they require very short answers, and we teach clients how to do that. That can be very difficult, but it's so critical. Section 5 is the one that I say is so important, and I don't care if the clients give short answers here, unless they're not too long, but it's how's the collision affected you? And I could talk more about each section if you're interested, but those 5 sections, when you're preparing your client, if you break it down that way within at least 2, usually 3 meetings, then you can really have a client do well in the deposition.
Mm-hmm. And why do you believe it's important for attorneys to prepare their clients for depositions?
It's the one time that the defense lawyers and the adjusters or the decision makers, whatever type of case you're talking about, they get to look at the client, and if it's a video, or they see what the testimony is, and the lawyer. When I was a defense lawyer, the first thing I would do is get in my car, get my dictaphone out, and say, the deposition of Joe Smith today went well. However, Mr. Smith is very credible, makes a very good impression. I think the jury will believe him. And that has a big impact on whether the case settles or not for a good amount, or whether you need to go to trial.
Now, let's break down the depositions by sections. You mentioned 5 sections. What are those 5 sections of each deposition?
Okay, so I'll go 1 through 4, and then we'll talk about 5 at the end. 1 is the background section. And there's 2 real overarching ideas that are important. Number 1, we have to be completely credible. We have to be no overreaching, no exaggeration. Credibility is key. So I tell my clients there are 2 things that they need to do, and they're very surprised. I call this in meeting 1, I call it the perspective meeting. And that in that meeting, we're saying there are 2 things you need to do. 1, you need to tell the truth, of course. Then number 2, you need to connect with the defense lawyer. And they look at me like I'm crazy. And most of my cases come from other lawyers, and they sometimes are there with me. And of course, they may have been in the prep, they may have been told about it before, but they'll look at me like, connect with the defense lawyer? Are you crazy? Did I make a mistake bringing you to this case? But if you think about it, when that lawyer takes a deposition, if they like the plaintiff, then they will go back and say what I just said a minute ago when they report to their adjuster. So when we take that in that context, number one, the background section is, of course, it sounds like all the questions about work, family members, jurors, relatives in the county that they're in, just to make sure they're not on the jury panel. All those questions that we all sit there and is everyone's probably, if you've done this a while, had their client say, "Why is that important?" during the deposition. I've had one or two. And I make sure that does not come across well at all. So I make sure and prepare my clients for these long questions and that they'll be wondering, instead of wondering, why is he asking me that? They're going to know. And if you're asking yourself, why is he asking me that? Then you're not thinking about the question and your strategy. And so that really is for the background section the most important. Number two, facts of the collision. And there's a lot of specifics to that. In the interest of time, if you have questions, I can answer more. But we all know time, distance, things like that. We go over all that. We go over the police report in great detail and do a mock cross-examination. The third section, not necessarily in this order, is prior medical, all the falls, all the doctor visits, hospitalizations, car wrecks. I make them ready for all of that. And then number four is, okay, and I joke with my clients, lots of defense lawyers say, from the top of your head to the bottom of your toes, tell us every single body part that was injured in this collision. And what we do in that situation, is we make sure that at a minimum, they review in detail what they said at the first and last visit every time. And there are lots of other things we talk about, but I just think that's so important because those questions come up so often. So that's 1 through 4, all short answers, and we practice those short answers. And then 5 is you talk all you want, and it's how's the collision affected you? And that takes, there's more to that. That's probably the most to talk about of all of them. So I'll let you, if you have any questions about that or other parts that I just mentioned. I don't want to talk for too long all at one moment. So
that's extremely informative. So are these 5 sections of each deposition something that you personally developed, or is it in the book of law, or is it a standard?
I guess you could say that I developed calling it that, but I learned it from other lawyers, from trial and error, doing it, thousands of depositions over the years, seeing like for instance, one of the things that I had developed, a lot of things that I just mentioned, I've gotten ideas from other lawyers who are really great. Some of my mentors over the years have been great about teaching, things to me. And but the whole I tell the clients about the whole speech that the lawyer gives at the beginning, where they say, "This is the deposition of Joe Smith, taken for all purposes allowed by Georgia law. I propose we reserve the objections," and it goes on and on. Because I don't want them to hear that for the first time at the deposition and say, "Wait a minute, am I supposed to be, knowing what's going on here? I don't remember John telling me about that." And my analogy to that is, if you look at golfers, I don't play golf anymore because I hurt my back years ago. But golfers don't care that much about what the person next to them is doing, the other golfer. They care about the course. Do I hit it short? Do I hit it left? Do I hit it right? Same with the clients. You are on your story. We're not really worried about what the defense lawyer does, as long as we tell the truth and we answer those questions in short questions 1 through 4. So I think that, that is a real help to clients and take some of the stress off them when they are not hearing things for the first time and they know that they're on their game. Because if they're thinking, why is he asking me that? Or what does it mean to reserve the objections? Then they're not thinking about our golf course, which is our story.
That totally makes sense. And John, here's just for a second off topic, totally. You mentioned some of your mentors. Would you like to mention a couple of some of your greatest mentors that you would like to give credit to?
Sure. I think one lawyer I graduated with is one of the most talented lawyers that I know, and is Nelson Tyrone, Joe Freed in Atlanta. Joe is just so generous with his time, will answer questions. And when I see his name on a list of speakers, I'm likely going to try to get to that conference. Mark Lanier, I go every year in June to the Lanier Trial Academy. I love learning from him. I've got this trial guides. I probably should get a free set of state knives or something. I've got so many books from all these folks that are teaching trial work. So, Sari D. Lamont is another trial consultant out in Oregon. I love the stuff she does with Vordire. So all those folks and more. I'm sure I'm gonna regret not mentioning more, but we don't have an hour and a half to talk about all those folks.
So if you remember later, we'll list them. I'll list them in the hashtags at the end of our episode. Okay, let's move on to our next question. How does the organization of these sections facilitate a smoother deposition?
Well, so one of the big things that is a impediment to the client understanding what's going on. We start with this we'll talk about this. We start early, but the client is thinking they can be the most truthful person there is, but they're still going to think sometimes when a question is asked, what does my lawyer want me to say? Am I going to upset John if I say yes and admit that the answer is yes? Or am I going to argue with the person? Well, if we have organized these sections and made it known to them that this may not be the order they come in, just remember, we want you the ultimate goal, and I tell them this at the end of the deposition when the lawyer leaves, I want you to look over to you and say, how'd you feel about it? And I want my clients to say, I was totally prepared for every single question. If that happens, then I've achieved what I want. If they are not prepared for one single question, then I have missed the mark. So making sure it's in sections gives them a clear understanding of how we think about the case, and that's particularly important with Section 5. How has the collision affected your life or the injury affected your life? And but it just makes it their understanding is like they're on the same page that we are, and they're not wondering those types of things, which lets them focus better.
Just doing your homework, that's very, very important. When we think of client preparation for deposition, do you have any initial steps that you take when preparing your clients for their deposition, John?
I do. I literally start day one, maybe not the initial client meeting, but pretty much a little bit. We start talking about the importance of storytelling, which I can mention more when we talk about 5. And how to be more persuasive, how to be thinking about what happens. The initial client package, we give them 2 things. This is a John thing, and I get, it's not entirely a John thing. I got to shout out to another mentor I didn't mention, Ken Shigley, who's now who wrote the book Law of Torts, Trial Preparation. There's an injury inventory in that book that I use, and I've got it where clients can do it online now, or they can do it in hard copy. We'll mail it. We ask them, do you want a hard copy? Do you want it online? We give them a hard copy day one, but we make sure and ask. We stay after them about, and but the injury inventory has all the things that we do on a daily, weekly basis. And then it says on the left, do you do this at all now? Or number 2, the other column says, just beside that, is it affected in any way? And with that, though, we give them a copy of the Georgia jury instruction on damages, so they can understand, all right, wow, there are 8 different, used to be 9, 8, I think 8 different factors now. 1, loss of enjoyment of life, interference with normal living, fear of the extent of injury. And we start thinking about those things early on, and spouses are so important here because they can tell the difference between what normalization means. I've always had a bad back. I don't remember, like when I reach into the dryer to get that last sock that's always in the back, I hurt my back. I'm like, oh no, what have I done? My brain doesn't go back to the day I lifted that case of drinks and ruptured 2 discs in my life. It just says I've got a bad back. I got to be careful. So blending when it happened and what's changed as early as possible is so important. And again, having them on the same themes. What do we have to prove to this jury? Well, that jury charge, they start reading it the very first day. and they keep their own note. We give them a 3-ring notebook. They take it home, they add to it, they bring it to every meeting. We do lots of Zoom calls too. So um, I hope
Thanks
that answers.
God for thanks God for Zoom. That's one good thing that came out of COVID.
Yeah, it really is. It is. My
And
largest
they,
trial ever. I never met my clients until my largest verdict ever. Never met them until voir dire because I got called in 15 days before the trial, and we did 15 hours worth of Zoom testimony prep, which is a whole nother talk. But
wow.
uh, anyway, Zoom's great.
Amazing. Now, based on your extensive experience as a trial lawyer, Jon, how can attorney effectively communicate the importance of each section to their client?
Well, some of the things we mentioned, like starting early, is very important. Repeat meetings is very important. A lot. I don't want to sound. I have had depositions in my career, of course, where I met with a client one time before the deposition. Does that happen now? Never. You know, and usually it's 3 times. So, and if you meet with a person that many times, then that communicates this is important. You know, and you also tell them that this is the best thing. This is one of the few things, maybe the only thing that they can do themselves to win their case. You know, this deposition, and if they do, but I don't stress doing well because that contradicts with tell the truth and connect, right? You know, and so what I'm after with the 3 meetings, and I don't know how we could do it if there weren't at least 3, is after a while, after maybe the 3rd meeting, the light bulb comes on and it's like, oh, this is becoming much more understandable. Now I can think for myself when a question comes through and I know what the theme is. I know what I don't have to ask, what would Jon want me to say here? You know.
Repetition and preparation is the key for everything in life, I guess.
Mhm.
Do you have any particular tips that you provide to your clients on how to answer questions during their deposition? And I know that may sound like a redundant question, but I think it's real important.
That's a great question. And I'm going to tell you the best answer I ever got from someone else. Working with a trial consultant out in LA. I don't even remember who it was, but we were working on a case and we ended up doing really well. And the client was so upset and angry about numerous things that he should have been angry about. And we really had to work long and hard with him. And so we don't want clients explaining problems or advocating for themselves in depositions. And that sounds like that's crazy, but I can explain. But she said, and I've used this ever since, when you get a question that, golly, and you think to yourself, the answer is yes, but that sure doesn't sound well. For instance, isn't it true you've suffered from a long-standing chronic back pain? The client should say something like this, perhaps. I wouldn't put it exactly that way. And then, of course, the defense lawyer cannot help themselves but say, who could? Um, well, how would you put it? And that transfers the power to the person, the client, to say the true answer in their own words, which is like, well, I've had low back pain for a long time, but only since this collision did I get this cervical disc pain that caused by the herniations that I got in this truck wreck. And so that's a great way for them to respond so that it really takes the sting out of the way the question's asked.
Tipping the scales, absolutely. What common challenges do clients face during depositions, and how can they overcome those challenges?
The number one thing is when you give a long answer in numbers 1 through 4, you
Mhm.
do many things. The lawyer is writing down all that. And then when the lawyer says, if you give a long answer and the defense lawyer says, all right, let's unpack that. I'm like, oh, because what you've done is you've created, instead of 2 more questions about that subject, you've created 10,
Open
right?
can of worms right there. Mhm.
Exactly. Great analogy and or metaphor. And I tell you, you know how that really hurts? The questions may be answered great, but you're tired. If you give a 3-hour deposition, you're really tired by the time it's over, which we have a 45-minute rule. 45 minutes, you're fatigued, we take a break.
Mhm.
And I politely ask the defense lawyer, hey, whenever it's a good stopping moment, we'd like to take a break in just a minute.
I like that
And,
strategy. Mhm.
and I think that gets them up. They can usually they have bad backs or necks or some kind of injury. It gets them up, and that makes us kind of a little bit of clarity in the way that we're thinking at that point. We don't talk to them, of course, during the breaks because that's not ethical, but
Mhm.
at least it gives them time to breathe, you know. So
Mhm. Mhm. Do you conduct any role-playing exercises with clients to maybe simulate the position experience? If so, how does this help?
we do role playing in two ways. I'll do a mock cross if I'm working with another lawyer, which is a lot of times. We'll divide that up and we'll videotape it for the client and let them look at it and show them what things are good and what things are bad. One of the other types of role playing comes from the Trial Lawyers College, where I'll give you an example. We had a guy who really wasn't good at articulating all the problems he had. He was a college football player. He was about really big guy. I didn't look injured. That was funny during voir dire, but we role played the day that his doctor said to him that he thinks he's going to need surgery,
Mm.
and so my client had kind of forgotten about that because it had been well over 2 years since that happened. He never ended up having it, but when we reenacted it, he remembered. Gosh, 2 days later, I went to my physical therapy appointment, and there's a guy that's only 10 years older than me who I'd already met. We were friends, and he had the same surgery that the doctor said I needed. And he was a police officer, and he was on a walker. He was in there
Mm.
doing, after surgery, doing aquatic therapy. Is all he could do. And he said, oh man, I just froze. And I thought to myself, I have an 8-year-old daughter. If I have surgery, am I going to be in that bad shape? And he said, I would just rather live with the pain than take that risk. So he declined surgery. And that was very important to the jury in that case when we ended up bringing that out in court. So that's a role playing too.
Wow.
That
That's a great story, and I bet a lot of people feel that way. I have a story just like that myself, but that's for another episode. John, can you share a success story where effective preparation led to a favorable outcome in a case? And I know you have so many stories. And by the way, how long have you been practicing law?
I guess I'll start my 28th year. This is my 28th. It'll be 28 years
Wow,
this year.
congratulations.
And I thank you. I've tried not as many as a lot of lawyers, but 60 trials probably all together to
Oh,
verdict.
goodness. Wow.
Yeah. And but one situation was it was actually called in kind of late to the case. Um, and this was a situation where I won't tell you who called me in or anything, but we were sitting in trial, and the defense lawyer told the client, this is how lack of preparation versus preparation. The trial lawyer, the defense lawyer said, you haven't told us about at least two doctors, is that right? And I look over for counsel, I'm like, why don't we know about this? Because I've been in this case 5 days. And we she says, no, I haven't. And she tells them about two pain doctors that we didn't know about that were after her
Mm.
last treatment that we knew about. And so it was 4 years ago when we thought she finished, or 5 years actually. And then so that night, and then we went through the case, and the cross-examination went on, and he went through 8 different visits where an injection was offered, she declined, and but she got 120 Oxycontin. And then he did that each time there was a visit. And then you visited the next week or month, didn't you? Yeah, or whatever. But you got your Oxycontin. He did it 8 times. I'm thinking to myself during that trial, we are going to lose. The jury may ask us to pay money, right?
Mm.
It's so
Ooh,
bad.
ooh.
That night at the hotel, I said, we're going to put you back up on the stand because I remember something you told me. And this is all public record, and I won't mention the case or where it was tried.
Mhm.
But, and she said, I said, your son, you said you struggled with addiction before. Yeah. Why? Well, my son died at age 17. Okay. Then I stopped for a while. Then I had a workers' comp injury, started back for a while. And then when this wreck happened, doctor offered Oxycontin. I started taking it. And yep. I said, so if I put you on the stand, will you say I'm an addict? I'll say I'm a recovering addict. Great. So this is what happened the next day. Back on the stand, ma'am, you're an addict. Is that true? She says, I'm a recovering addict. How long have you been in recovery? For 4 years. I said, so you've been in recovery since the last time you saw the doctor we learned about yesterday? She said, yes, that's right. I said, and so, well, were you in pain as a result of this collision? I was in terrible pain. Have you been in pain during the trial? Yes, I'm in terrible pain right now. Well, let me get this straight. Why did you, um, you know, you were drug seeking when you were treating for this collision? I was. Okay. But yet you were in pain, correct? But why haven't you seen a doctor in the last 4 years? She holds up her chip. I've been sober ever since then. And if I'm so afraid that if I go back to a doctor, they will try to convince me to take narcotics, and I know that would kill me. So I will never do it again. So that's why you haven't treated in the last 4 years, correct? And then you could hear a pin drop. So the worst fact in our case was she hadn't treated in 4 years, and we learned about doctors we didn't know about. So we turned it around. She completely admitted what the jury already knew. What a risk to put her up there and say, were you drug seeking in our case? Yes, I was. And because you ask yourself every night at trial, what is the most honest thing that I can tell this jury that they know? And to put it in context and to let them give it to them and trust them to do the right thing. And they did. 10 times the medical bills plus attorney fees. It was a really great lesson for me, that risk taking and preparation. I'll link it now to preparation. The preparation was so important because I had known those things about her. Even during that time, I spent all my time talking to her before that trial, to make sure I knew her story as well as possible.
Wow, what a great story. That gave me goosebumps. Amazing, amazing. Wow, I wished I was in that trial sitting there in the hall. After a deposition, what follow-up steps do you recommend for clients, Jon?
Well, one of the first things for sure is we read and sign depositions. We make sure they have the chance to read their deposition and use the errata sheet to revise or even change answers in some situations. If you're on Zoom, sometimes you may not get an accurate transcript. Or if you have an elderly client, especially, I didn't hear him. I thought he said can versus can't, or things like that. So they read it. We go over it together and we make sure it's worthwhile to change. We also do a summary of the deposition and get it to them as fast as possible, and part of their notebook that they keep. And, I've learned this. If you send the client 40 pages, they'll read zero. If you send the client 10 pages, they'll read 10 pages most of the time. But so it's just overwhelming for them to read an entire deposition, 80 pages, whatever. So we do a summary and we give that to them, and we say, how important is it? And was it in school? If you had learned everything the entire time, long before you had to cram for the test, start now, learn it, read it now, see what you've done, make notes. Let's talk about it, at a meeting once we start the trial prep process and how we could have done better and things of that nature. So that's the number one thing, I guess.
And each client usually goes through more than just one deposition. How can clients reflect on their performance to improve for future depositions?
Really, and we don't have a lot that do that, I guess, but I mean, sometimes we got one coming up next week pretty soon because it's been so long since the first one. They've had so much treatment since then. We just make sure they're fully prepared. Again, they've already been reading, the summary. We do 2 meetings at least where we're taking the first meeting is the nose dive into that transcript to look at what problems there may be. And then the second one is to fully prepare them for whatever's happened since then, because we will limit the deposition to what's happened since then. So that's a little easier process for us.
Now, let's shift the gears now and talk about taking risks at trial when you have no other good options. Can you discuss what it means to take risk at trial and the context in which this might be necessary?
Yeah. Well, the other example with the lady with the narcotics is the best trial example I can think of. There's lots of other risks at trial, like when you're trying to decide, offer of settlement presents risk a lot. If you send one to the defense for amount, and if you beat that offer by 125% at trial, then you get your attorney fees. Well, typically, if you send one, you'll get one back, and the client needs to know the risk of that exposure. What if we lose the case? And then they have a motion for them for $40,000 in attorney fees from the defense. So that presents a risk that you take during trial that, okay, especially when the jury's out or before the trial, during the trial, do we talk to them about a high-low? Because, how did it go with the issue of liability? If it went bad, we need to consider a high-low that's going to protect our client from that offer of settlement. And then other risks at trial are, I learned this from Lanier Trial Academy. You can ask questions on cross that you don't know the answer to.
You said
You
you
really,
cannot or can?
you can. I think it works in there's some great answers that have come out of questions where you don't know exactly what they're going to answer. But I'll say this, you try to tailor those questions to where if they answer it either way, you're still okay. You know, it's kind of like the trucking case where you agree this is safer. If they say no, I don't, well, you've got them being unreasonable. If they say yes, I do agree it's safer, then they agree with your expert. So you've asked a question you don't know the answer to, but yet either way you win, because you've asked a question that's, put them in a position where they've got to commit one of the two.
And I don't think, John, we mentioned what types of cases do you handle at your law firm?
We handle, for the most part, automobile and truck collision cases. I would say we probably have 30 to 40% trucking and the rest automobile collisions. We really enjoy working on both. The trucking cases are so different than car wreck cases. There's a whole other, body of regulations and laws and things that apply to those cases. So it's great when like a young lawyer brings one of those cases to me. I automatically respect them because they realize, you've got to have done a lot of these to know all those things and learn from people like who I mentioned earlier, Joe Freed, Michael Callan, Trial, those types of things. You got to really, Christy Childers here in Macon, who does a great job with trucking cases. She and I worked together for a few years, and she and I worked together some. So learning those things and those nuances are so important.
And those interesting, you mentioned, how complex the trucking cases are, and especially now with AI advancing at the speed of light, it's something new comes out every day. So yes, you definitely need an expert like yourself, for those cases. What are some scenarios where an attorney might feel they have no other good options?
Well, I would say, and this may not pertain as much in Georgia as it did before, a recent round of tort reform, but we've had several trials where we would completely waive the medical bills because various different reasons, anchoring, things of that nature, but also from a credibility perspective, let's say you can't get a juror off that's spouse works at the same, like at the Air Force Base. They're not in the same section, but they all share the same health insurance. They know for a fact that spouse is going to say in the jury room, why are they asking for these medical bills when, when they're all been paid by our health insurance? If their spouse works there and all their bills are paid because it's great insurance for the government, then you don't have a good option other than, in my opinion, credibility, dictates. And then another risk, I haven't done this. I've heard of a lawyer, a very excellent lawyer out west. I can't remember exactly where, but they had a case where they had their client not present for almost the entire trial. I've had clients leave during before and after witness testimony, which I think is a good idea, in other parts of the trial. But when the client does not make such a good impression, or for other various reasons, you may want them not to be present at the witness table the whole time. We all think it's an advantage the plaintiff sits closest to the jury, but sometimes it might not be an advantage, if your client is doing things during the trial or we're worried about how they react. But when you're assessing these risks and the factors, you really are just using what we talked about earlier as your benchmark. Is what is the most credible thing that we can do? What is the most honest thing that we can, do, and what's most credible? What's the jury going to believe is the most credible, decision that we make or whatever it is that we do with risk or anything else.
Honesty and credibility are so essential during any part of each case. Thank you for emphasizing that. How can an attorney develop a strategy that incorporates risk taken in the face of a challenging case? And I know, John, most of your cases, if not all, are super challenging.
Yeah, I mean, we don't get referrals from lawyers that are cases that are easily settled, although it really, the great Jim Butler will tell you, and other lawyers will tell you that you should try your good cases, not your bad cases, because, those are the ones that, that need to be tried often, not always. But what a great teacher he is, but just watching him on CVN. But I think that the strategy incorporates taking is that put yourself at first, the lawyer, in your client's shoes. Think about how you would like to be treated. What would you tell your relative, your spouse, your brother, your sister, about risk, and adequately inform them in writing. In writing is not just, of course, it protects us from, hey, you never told me that, but it ensures clarity. I do this little part of one of my little talks about believe it or not, I'm 5'8", but I made a 4A high school basketball team. I didn't play much, but I made the team.
You sound like me. I'm a little midget, but I was on a professional girls team for 2 years, but playing basketball.
Wow, that's awesome. Yeah, so my story, much less, but you'll relate. I think maybe you'll agree. My coach taught me something so important. I made a pass to a guy, and in my view, it was the perfect pass. He should have taken 2 steps and laid it off the rim or dunked it. He could dunk. Of course, I couldn't. But but he missed it. It went out of bounds, and it was a turnover. And so after the game, I'm like, gosh, man, we could have won that game if it hadn't been for Johnny missing that pass. The coach says, John, come in my office. I went in there. He says, what if that pass should have been a bounce pass? What if it should have been just a little bit, softer? What if he should have lobbed it a little bit to give him a better opportunity to collect himself before he caught the ball? That pass was not the perfect pass because it resulted in a turnover. And so as a lawyer, my pass to the jury, my communication to the jury, if they don't get it, it's not their fault. It is my fault for not adequately explaining it to them. Just like that, it was not the perfect pass, right? So, that's something that the strategy is to communicate in writing with the client, developing that strategy, to make sure they fully understand what the risk is. And because they may not always understand it if it's just verbally.
And how do you communicate those potential risks or pitfalls to your clients? And how do your clients typically react to it?
I've been very fortunate, and maybe it's because I'm older now. I don't think I remember this. In fact, I remember one particular trial where I really wanted the client to settle, and they really needed to settle, and they didn't settle. And we tried the case, and I'll admit to, hopefully there's not too many judges out there right now, but I admit one of my trial strategies was to try to not create it, but object like I don't normally object if there's any chance I can preserve error. I didn't purposefully create error, but there were 8 enumerations of error for the appellate lawyer in that case. I couldn't
Goodness,
believe it.
wow. Wow.
Never had one because it was such a bad case. We just we were going to get tagged. But anyway, so to communicate it I think it needs to be most of the time in person if possible, with the writing to supplement it. Because because then again, you're adding that certainty of communication. You're putting yourself in their shoes. Our client, how do we compete with bigger firms that have marketing? Service. We want to treat them the way, FedEx sent a check up to New Jersey instead of North Georgia the other day. We got somebody in the car and drove a new check 2 hours to them instead of stopping payment and sending another one. We wanted that you've got to service the client in a way that makes sure that they understand you value them and you value and understand, hey, I don't want you to face a risk that I wouldn't want to face unless I had all the information. And they typically are so kind and they say, John, I trust what you're saying and I'll do what you want. And you've got a good client when they say that.
Absolutely. Do you provide, John, any guidance to your clients about understanding the possible consequences of taking risks at trial?
I really do. I give them the worst case scenario. I tell them, with the guidance, I say, look, here's an example of how it could go badly. If I know of a situation where it did go badly, I'll say in a case like this, for instance, um, we had a traumatic brain injury case years ago. We really worked with the client hard, school teacher who on cross just could not help but fight with the defense lawyer about whether she was a good teacher now or not. She was proud of the work she did. It took her twice as long to complete that work, but she could not admit to him that yes, it's different. And so she appeared so capable to the jury during that cross-examination that the jury's like, we really don't think you presented your case with enough evidence to show that she has this traumatic brain injury. And so they didn't find for that particular injury in the case. They did give us a verdict for the rest. But that's really the important thing is you've got to make sure you show them a situation like now with a traumatic brain injury client. I really emphasize that when we're talking about settling the case or taking a risk at trial, about claiming some portion of their damages.
Mhm. Once you decide to take a risk at trial, and that may be a split moment, very short moment, how do you manage this situation if things don't go as planned?
Yeah. So I'll tell you, that's a great question, and it comes up a lot. And so when I go to a trial, I know, during the trial, before the trial, and then at one point during the trial, we really do get with the client about, all right, what's the ask to the jury? How much are we going to ask for? Is it going to be a range? Is it going to be, a very, very high number, or is it going to be adjusted from what we talked about the last time we talked about this? And so there are times where, you wonder if I ask for too much, am I going to lose credibility with the jury? Are they going to think I'm a greedy lawyer? And my hope is this: if they've seen me 3, 4 days, they know that me well enough by now that they're trusting me and they're trusting our case because we have been credible. But that may not always be true. Again, you can't get everybody off a jury that you want sometimes. And so I think that with the main thing about deciding that is I go in and I say, okay, I might change my mind during the closing. Do you give me the authority to change my range or my verdict? And let's say I wanted to ask for 1.8 million. I don't feel it. I just don't feel like that's where I need to be. Do you give me authority to go as low as 1.2? So, and then during they've given me advanced authority, obviously, because that's, they have to give that authority. And then, when I take that risk, I'm managing the situation. I had gone into that trial thinking we were going to ask for 2 million maybe or 1.8. And then during the trial, something went in not as planned. Now I don't feel as good about that number, or I feel higher. It's gone great. They knocked it out of the park. So how do you manage that ask is again, I think you said it earlier, Laura, planning and preparation and thinking of these things in advance and making your client involved in them is a really good way to present that.
Thank you so much for answering this so thoroughly, John. How do you balance traditional legal strategies with innovative risk-taking in your practice?
That's another good question. I think that balancing the traditional legal strategies, you obviously got blocking. I call that blocking and tackling. Sports is always my metaphor, and so you've got to do the fundamentals. You've got to understand. Like I coached a little team one time in football, and our two cornerbacks were the kids that we weren't sure about. Well, we spent the whole 2 weeks before the championship practicing with them only. We knew our stars were going to show up, so work on where we can have the most runway to improve. And so, that's kind of the way I approach cases. I look at what are the issues that have the runway that needs to improve. And if all the basics, like the legal strategies that we all employ, which we've been employing throughout the preparation of the case, or where they need to be, then what is it that innovatively we can do? Like, would you mind if the judge permits coming off the witness stand for a second and demonstrating that for the jury? That's a little innovative, trial lawyer college material stuff. And so they come out, it does lots of things. Of course, our goal is for a jury, instead of to be looking at their watch thinking about the grocery list, we want them, leaning forward. What's he about to do now? Um, uh, that's one example. The Lanier has, taught in his seminar about a document camera. We bring it's like an old Elmo, but it's a portable document camera. So I can show jury the things on the PowerPoint, or I can show them on my Elmo. And during my closing argument, typically I switch from one to the other. What if the judge doesn't give me the jury charge I want, or changes the verdict form? I don't have time to put it in the PowerPoint. And because he says, let the jury come on in. I'm like, you forgot what it takes to be a trial lawyer, And so then you got to put it on your IPVO, or
Mm.
whatever camera. I understand there's some others out there, and you got to be able to show it on the screen and be ready for that. So that's always a balancing act, and it's thinking of trials in terms of presentation versus a trial. You are presenting something to the jury, not just trying a case. Yeah.
And John, if anyone has questions about what we talked today, which was 5 sections of the deposition and how to properly prepare your client to each deposition, and also how to take risks and sometimes unexpected risks during the trial. Or if somebody needs your legal help and looking for your office, how can they find you?
They can call our office, or they can go to my email. My email's a little funny. Someone took hawklawfirm.com, so I had to get hawklawfirm.law. So it's Jon. Yeah.
I
Yeah, I
like
got
that. Yeah. Uh-huh.
you do miss some emails. People say it bounced back. I'm like, you said .com. But anyway, it's Jon at hawklawfirm.law. Hawk is HAWK law firm. And I love to talk about this stuff. So I don't have to be hired. I would love for someone to call me and say, "Hey, I got a better idea than what you talked about. I want to get better for my clients." And or someone that wants to call me and say, "Hey, I really like what you said. Let's talk about it more." That can only help both of us. And a rising tide lifts all boats. So
Absolutely.
I really enjoy doing this, and your questions were so well thought out. Thank you for challenging me with those. It's been fun.
Oh, thank you so much, John. And this was so great. I'm truly blessed to have you on my show, and hopefully we can do another episode soon because there's so much more to cover, right? And
Sure is.
I hope our discussion about the risks and rewards when navigating trials when stakes are high was informative and educational. And as promised, here's a fun pop question for you. You ready?
Okay.
Can you describe a moment when you took a significant risk that paid off? And this could be trial related or not. It could be life related.
You know, um, so I was offered a job. I worked for 5 years for Lowe's Home Center before I went to law school. And I was offered a job to go to the brand new Charlotte, North Carolina. Grew up in North Carolina. The first floor they had where there was the warehouse thing like Home Depot took off with. And they were bringing in the number one store manager in the company, from Wilmington, North Carolina, to run that store. And I was offered the assistant management job there. And then there were two of us that were all, that were going to be assistant managers. I was ready to move to Charlotte, and they were opening another one right down the street in Pineville, which is another booming area of Charlotte. And it was going to be another store just like that. So, of course, one of the two assistant managers had a direct in to be the manager of the entire store. And I loved working at Lowe's, helping them start and open up new stores and things like that. But something made me I went to dinner with my parents to talk about it. And they were talking about a lawyer from Whiteville, North Carolina, where I lived until I was 4, and how great he was in the community and respected, and how he did things for people. And something just lit inside me, watching them talk about it. And I said, you know what? I'm going to go back to school. Never thought about being a lawyer. I haven't even finished my 4-year degree yet, and so I finished it, immediately applied for law school, got into the University of Georgia. And sometimes I think about what it would have been like, but I really feel like the Lord put me in the best place to be and this is what I love doing. This is where I think I help people the most. So that was a risk that I hope paid off. I hope my clients would say that it paid off too.
And I think, John, not just your clients, but also colleagues, not just in Georgia, but nationwide, blessed to have you as an advocate for people. You're amazing. That was again trial lawyer Jon Hawk with Hawk Law Firm based in Macon, Georgia. I want to thank you all for listening and watching our episode today. For more tips and tricks on legal funding and personal injury law and medicine related topics, follow me, download, like, and subscribe for It's Time for More Injury Funding podcast on several podcast platforms worldwide, and follow More Injury Funding on LinkedIn, Instagram, Facebook, Twitter, TikTok, Pinterest, YouTube, and Google Business Profile, as well as my website at moreinjuryfunding.com. I can't wait to see you, my dear listeners and viewers, of my next upcoming episode. Tune in for our next guest soon. Until then, be well. Thank you.